Nobody warns you that the most humiliating thing a man can experience in a courtroom is not losing. It is standing in a room full of strangers while another man points at your shirt and explains to a judge why that shirt is evidence. Evidence of what you are worth. Evidence of what you never were. Evidence, he said, of a man who had contributed nothing to 34 years of marriage and had therefore earned nothing from the dissolution of it. I want you to understand something about me before I tell you what happened next. I have never owned a shirt that cost more than $40. Not because I couldn't, because I didn't see the point. I still don't. My name is Gerald Cobb. I am 67 years old. I was born and raised in Columbus, Ohio, and I have lived here my entire life, except for 2 years in the early 1980s, when a contract took me briefly to Raleigh, North Carolina. I came back as fast as I reasonably could, because Columbus is where my people are and where my roots go down past anything a man can pull up in a single lifetime. I want to tell you about the morning I walked into courtroom for the Franklin County Common Pleas Courthouse in a shirt I bought for $14 at a Walmart off Broad Street, and what happened when the other side of the room decided that shirt was the whole story. Welcome to Dad's Raw Revenge. Get comfortable, because this one is going to take you somewhere. Drop a comment and let me know where you're watching from. Hit that like button and make sure you're subscribed. Trust me, you are going to love it here. I spent 34 years doing what I was built to do. I am a mechanical engineer by training, University of Dayton, class of 1979. I went to work for a mid-sized industrial equipment manufacturer on the east side of Columbus 6 months after graduation. I wore a hard hat on the floor for 2 years before they moved me into a design role. I wore a tie in that design role for 4 years before they promoted me to systems lead. I wore the same shoes to that job every day for 11 years. Brown Rockports, resold twice. And I never thought once about what those shoes signaled to anyone, because I was too busy thinking about stress tolerances, load-bearing specifications, and the very specific satisfaction of a mechanical system that does exactly what it is designed to do and no more. I left that company in 1994. Not because I was pushed out, because I had spent 15 years watching men make decisions about the business side of engineering, and I had come to a quiet conclusion that I could do it better. I want to be honest about something. That is not a boast. It is a diagnosis. I am not a man who talks about what he can do. I am a man who does it and then goes home, makes coffee, reads a paper, and lets the results speak in their own time. In 1994, I founded Cobb Mechanical Solutions. We manufacture precision components for mid-range industrial equipment, custom tolerances, small batch runs, clients who needed parts that nobody else would bother to make at their volume. I ran it out of a lease bay on Fisher Road for the first 3 years. We had a coffee maker on a folding table for employees counting me, and a used CNC machine I had refurbished myself over 2 weekends in February. By 1998, we had 16 employees and had moved to a proper facility off Alum Creek Drive. By 2003, we had 41 people. By the morning I am telling you about, we had 87 people drawing a paycheck from a company whose name I never once put on my truck, my jacket, my business casual shirts from Walmart, or a single item of clothing I wore to a family dinner. I drove a 2007 Chevrolet Silverado, dark blue, 112,000 miles on it, because it started every morning and got me where I was going without making a statement about itself. I had replaced the driver's door seal myself with a kit from AutoZone the previous spring. I like doing things like that. I have always liked fixing what needs fixing. My wife, Diane, had worked as a marketing coordinator for a regional medical supply firm for most of our marriage. She took a position at Allegheny Med Supply in 1991 and stayed because the benefits were solid and the work suited her. She became their director of marketing communications in 2012. She was good at her job. I respected that and said so regularly. When she came home late, I kept the plate warm. When she traveled for conferences, I handled the house without complaint. When she wanted to redecorate the living room in 2016, third time in 8 years, I said go ahead, and I meant it. I was not a difficult man to live with. I want to be clear about that. I was quiet, and some people confuse quiet with difficult, but they are not the same thing at all. The marriage ended, as many long ones do. not with a single event, but with an accumulation of small truths that eventually got too heavy to carry without dropping them somewhere. Diane had been involved with a man named Preston Hale, who worked as a regional vice president at Allegheny Med Supply, the same company, the same building, 3 floors above her office. I found out on a Thursday morning in October 2022 at 7:42 a.m. when I came home early from a supplier meeting that had been rescheduled and found a car I did not recognize in my driveway, a silver 2021 Audi A6, personalized plates. I sat in my Silverado at the end of my own driveway for 4 minutes and 40 seconds. I counted, the way I always count things, because precision is a habit you carry home from the shop floor, whether you mean to or not. I want to be honest with you. Something in me went very still. Not cold the way people mean when they say they went cold. Not rage pushing itself down into ice. Still, the way a machine goes still when it has been properly calibrated and is simply waiting for the operator to press the correct sequence of inputs. I did not go inside. I did not knock on my own door and make the kind of scene that would have felt justified and would have accomplished nothing permanent. I put the Silverado in reverse, backed out of my own driveway, and drove to the office. I sat at my desk. I made a decision, not an emotional decision, not a reactive one, a permanent one. By 9:15 that same morning, I had placed a call to Gordon Fry, a family law attorney I had been referred to 18 months earlier by a colleague who had gone through his own situation and had spoken well of the man. I had kept the number in a folder in my filing cabinet. I am an engineer. I keep things I might need. I told Gordon what I had seen. I told him what I suspected and what I knew. He asked me 3 questions, all of which I answered completely and without elaboration. At 9:47, he said, "Come in Thursday at 2. I said I would be there. I hung up, poured a cup of coffee, and went back to work. I have found, over 67 years, that going back to work is one of the most underrated responses available to a man in a difficult situation. Diane moved out in November of 2022. She went to Preston Hale's apartment in the short north, about 4 miles from the house on Kimball Drive, where we had lived for 22 years. She took what was hers and some things that were arguably shared. And she did not fight me on the physical division, because what Diane wanted was not furniture. What Diane wanted was financial resolution. And for that, she had retained an attorney named Douglas Carraway. I want to tell you about Douglas Carraway. He was 52 years old, a partner at a downtown Columbus firm that occupied the 14th and 15th floors of a glass building off High Street. He drove a dark green Range Rover, current model year, which I noted on 2 separate occasions from my vehicle across the street, not out of any particular feeling about it, but because I noticed details the way some men breathe, automatically and without effort. He wore suits that were the color of expensive things. He had the specific manner of a man who has spent 25 years being the most prepared person in most rooms he has entered, and who had stopped working very hard to conceal this from those rooms. He was, by every professional measure I could locate, genuinely good at his job. His firm had a documented record with high-asset divorce proceedings in Franklin County that was, I will say, honestly impressive, which made it interesting, from a purely structural standpoint, that he had accepted Diane's case without conducting what I would consider standard load-bearing research on the architecture he was about to challenge. I did not say this to anyone. I went home. I sat at my kitchen table at 9:47 p.m. with a yellow legal pad and a cup of coffee that went cold before I finished the first page of notes. I listed everything, every asset, every account, every entity, every document in existence. Then I listed everything Douglas Carraway's firm was likely to surface through standard discovery. Then I looked at the gap between those 2 columns. The gap was considerable. I am an engineer. I build systems with tolerances, and I account for the load they're going to carry. I had been building this particular system, quietly and methodically and without announcing it to anyone at dinner, for the better part of 11 years. If you have been listening for a while, do us one quick favor. Subscribe. A lot of people watch without ever doing it, but it costs you nothing, and it means everything to us. Hit the like button while you're at it, and drop your thoughts in the comments. Gordon Fry is 60 years old. He has the build of a man who was a serious athlete in his 40s, and has since redistributed that discipline entirely into an absolute stillness behind a desk. He does not use a laptop in client meetings. He uses a yellow legal pad, same as me, and a pen he refills rather than replacing, which I noticed on our second meeting and which told me something useful about the man. At our third meeting on January 9th, 2023, at precisely 2 o'clock in the afternoon in his office on Broad Street, Gordon set his pen down and said, "Gerald, I need to ask you something directly and I want the same in return." I said, "Go ahead." He said, "Is there anything about the structure of your business holdings, anything at all, that Douglas Carraway is going to find in discovery that is going to surprise me in this room?" I looked at him for a moment. I said, "That depends on how carefully he looks and how well he reads what he finds." Gordon picked his pen back up. He was quiet for about 6 seconds. Then he said, "How long do we have?" I said, "As long as we need." He wrote on that legal pad for 11 minutes, without looking up. That is not an estimate. I watched the clock on his wall. The discovery process ran from January through early April of 2023. Carraway's firm was thorough, and I want to give them their due credit. They pulled tax returns 7 years back. They subpoenaed records from 3 banking institutions. They obtained documentation on the Silverado, on the house on Kimball Drive, on 2 personal savings accounts, and on a Fidelity brokerage account that carried, by the time they examined it, a balance of $214,000. That is a respectable figure for a man in his mid-60s. It is also precisely the number I had arranged for them to find. It was real money. It was my money. It was also not the conversation. Gordon reviewed their discovery responses in early April and called me on a Tuesday afternoon to say that Carraway's team was confident. I said I knew. He said they believed the asset picture was complete. I said I knew that too. He said, "Gerald, I need you to come in Friday morning. Bring Margaret." I said I would. Margaret Sloan is a corporate transactional attorney operating out of a small 4-person firm in Dublin, Ohio. She is 57 years old, has spent 30 years ensuring that what people intend and what is written in legal documents are in precise agreement, and she has a habit, which I have come to rely on the way I rely on a good torque specification, of using the phrase as written with an emphasis that lands differently in every room she says it in. She prepared the original operating agreement for Cobb Mechanical Solutions in 1998. She updated it in 2003, in 2007, in 2011, in 2014, in 2017, and again in 2020. She prepared the trust instrument in 2012. She prepared the amended articles of organization in 2017 in connection with a specific acquisition transaction that had taken approximately 4 months to structure correctly and that had, since its completion, sat in a properly filed public record in the Ohio Secretary of State's office, visible to anyone who searched the right entity name. Margaret arrived at Gordon's office on Friday, April 14th, at 9 a.m. with a folder containing 7 documents. She set it on the conference table, put both hands flat on either side of it, and said to Gordon, "Everything is as written. My client would not change a word." Gordon opened the folder. He read for 4 minutes and 20 seconds. Then he looked across the table at me. He did not say anything for a moment. I said, "I know." He said, "Does she know?" I said, "She will." Margaret picked up her coffee cup, took a sip, and looked out the window at Riverside Drive with the expression of a woman who had seen the specific variety of surprise before and found it quietly satisfying each time. The formal settlement hearing was scheduled for May 8th, 2023, at 9 a.m., Courtroom 4, Franklin County Common Pleas. I arrived at 8:37 a.m. I had washed the Silverado the previous Saturday because it needed washing, not because of the occasion. I parked in a public lot on Mound Street, 3 blocks from the courthouse, fed the meter for 3 hours, and walked. I wore khaki trousers, brown Rockports, new pair, same model I have worn since 1989, and the blue-gray cotton button-down shirt I had purchased at Walmart off Broad Street 7 weeks earlier for $14. It fit me correctly. It was clean and pressed. I had pressed it myself on Sunday evening, using an iron I have owned since 2001. I do not own a suit. I have not owned one since my father's funeral in 2004, when I wore the one he left behind, because we were the same size and it seemed appropriate. I did not see the need to purchase one for a proceeding whose outcome I had spent 6 months preparing for, with a level of structural precision that had nothing to do with what I was wearing. Gordon met me in the courthouse hallway at 8:51. He looked at my shirt. He did not comment on it. He said, "Ready?" I said, "Since October." He came very close to smiling. He is a disciplined man. Douglas Carraway was already at the plaintiff's table when we entered, standing with a younger associate from his firm named Brian Alcott. Late 30s, good suit, the slightly alert posture of someone trying to demonstrate competence to a senior partner in real time. Diane sat at the table in a gray blazer and looked composed. She has always been composed in rooms that matter to her. I will say that without any particular edge in it, because it is simply true. I sat down at the defense table, placed my hands flat on the surface, and looked at the wall. Carraway glanced at me. His eyes moved from my face to my shirt and back to the room with the specific economy of a man cataloging an adversary and finding the catalog brief. He said something low to Brian Alcott. I could not hear the words. I did not need to. I have heard the register before. I have been hearing it my entire adult life, and I learned a long time ago that the most useful response to that particular register is no response at all. Judge Patricia Wren entered at 9:04. She was 61, had been on the Franklin County Common Pleas bench for 14 years, and carried the manner of a person who has processed every version of every human dispute and arrived on the other side of that experience with completely functional skepticism and zero tolerance for theater. She arranged her materials, looked at both tables with the same neutral attention, and called the proceedings to order. Douglas Carraway opened for the plaintiff, and he was, as I said, good. He walked Judge Wren through Diane's contributions across 34 years, her salary history, her career progression at Allegheny Med Supply, her management of the household during the years when my work required extended focus and travel. He was organized and precise, and he delivered his argument with the practiced fluency of a man who has given this particular shape of argument many times in many rooms, and has watched it land well. Then he paused. He turned toward our table, and at 9:22 a.m., I noted the time, he said the following, and I want to be precise because I wrote it down that evening. Your Honor, my client has spent 34 years building a life. The man at that table, he indicated me with an open hand, palm up, the gesture of a man presenting something self-evidently unimpressive, arrived this morning in a shirt from Walmart. I think that tells the court something about what he considers the appropriate level of respect for these proceedings. And frankly, Your Honor, it tells the court something about what this man has contributed to 34 years of my client's life. He let it settle. There was a very slight sound from the gallery. Not laughter, not exactly, but that loosening that happens in a room when a speaker has landed something. 2 or 3 people shifting. Someone exhaling. The particular acoustic of a room, deciding it has understood something. I did not move. I looked at the wall above Judge Wren's head, and I let him finish. The same way I have let men finish for 67 years, because I have found without exception that the space after man is done talking is where the actual information becomes available. Gordon stood. He said, "Thank you, Your Honor. Before argument, I'd like to submit Exhibit A for the record and ask that opposing counsel be given a moment to review." He carried a folder to the clerk, who logged it at 9:28, and provided a copy to Carraway's table. Gordon returned to his seat. I looked at my hands. I was calm. I want to be clear about that. I was not performing calm. I was not suppressing something that wanted to come out differently. I was simply calm, because the work had been done and documented and filed with the correct authorities, and there was nothing left in that room that required anything from me except stillness. I watched Douglas Carraway open the folder. I watched him read the first page. I watched him stop. He turned to the second page, read, and came back to first. His associate leaned over and read alongside him. The room was quiet in the specific way a room goes quiet when the 2 most active people in it have simultaneously stopped moving. Judge Wren had her own copy. She read with the complete composure of someone whose expression reveals nothing until it chooses to. She read for approximately 95 seconds. Then she looked up and said, "Mr. Carraway," he said, "Your Honor, may I request a brief recess to confer with my client?" She said 10 minutes. What was in that folder and why it mattered requires a small amount of context. In 2017, Cobb Mechanical Solutions entered into an asset acquisition agreement with Allegheny Med Supply's Ohio distribution operations. The transaction gave Cobb Mechanical a 51% equity stake in that distribution entity, a properly structured deal documented by Margaret Sloan, filed with the Ohio Secretary of State, registered with the appropriate tax authorities, and reported on every subsequent annual return. The transaction was not hidden. It was not obscured. It existed in the public record under the entity name that any competent search would have located, had anyone known to look for it. Allegheny Med Supply's Ohio distribution arm had processed $6.4 million in revenue in fiscal year 2022. It employed 43 people. Diane had worked in Allegheny Med Supply's corporate marketing office for 11 years. Preston Hale, the man she'd been involved with, held his regional vice president title under the same corporate umbrella. I had owned the majority of their distribution operations for 6 years. I had attended 2 of their company picnics as Diane's spouse. I had shaken Preston Hale's hand at one of them at a park shelter in Westerville on a Saturday afternoon in August of 2019, and had looked at my Silverado in the parking lot with the expression of a man noting something vaguely beneath his attention. After the 10-minute recess, Douglas Carraway returned to the room with the composure of a man who has absorbed a significant recalibration and has decided, professionally, not to let it alter his bearing. I respected that. He requested a 2-week continuance for additional discovery review. Judge Wren granted it. Gordon told me afterward that Carraway's team spent those 2 weeks conducting a complete entity search on every corporate filing associated with my name going back to 1994. What they found was accurate, complete, properly structured, and exactly what Margaret Sloan had built it to be across 29 years of annual reviews. There was no error to find. There was no concealment to allege. There was only a picture that was larger than the frame they had been looking at, and a man who had never seen any particular reason to mention the size of the frame at dinner. The continued hearing was May 22nd, 2023. I arrived again in my Silverado, again in khakis and Rockports. I wore a different shirt, a green one this time, also from Walmart, $11 on sale. I sat in the courthouse hallway on a wooden bench with a coffee from a cart outside the building and read the sports section of the Columbus Dispatch because the Clippers had played Tuesday and I wanted to know the result. At 10:17 a.m., Gordon came through the courtroom door, sat down next to me on the bench, and said, "They want to settle." I said, "What terms?" He told me. I folded the sports section. I said, "That's acceptable." He said, "You don't want a moment?" I said, "I've been thinking about it since October." He nodded once, stood up, and went back inside. I finished my coffee. The Clippers had won by 8. The settlement was finalized that afternoon. The terms are private, and I intend to keep them that way, not out of any desire for drama, but because I am a man who believes that some things are appropriately contained to the people who were present for them. What I will tell you is this. The 51% equity position in Allegheny Med Supply's Ohio distribution operations remained exactly where it had always been. Diane retained what she had brought to marriage and what she had rightfully earned across 34 years of her own work. The division was, by any fair accounting, equitable. I was satisfied with it. I did not require it to look a particular way to anyone else. I drove home on Broad Street in the Silverado. The check engine light had been on for 9 days, the oxygen sensor. I had confirmed with a code reader the previous weekend, and I had a replacement sensor on order that was due to arrive Thursday. I turned onto Kimball Drive at 4:38 p.m. I pulled into the driveway where a silver Audi had been parked 7 months earlier, and where now there was only the ordinary concrete and the oil stain from the Silverado's previous owner that I had never quite managed to lift with degreaser. I went inside. I made a pot of coffee. I sat down at the kitchen table. The yellow legal pad was still on the table from October, turned over to the blank side. I did not turn it back. I sat with the coffee and let it go cold, and I looked at the window above the sink where the afternoon light comes through in a way I have always liked, and I did not feel triumphant. I want to be precise about that, because people sometimes expect a feeling to be triumph, and it is not, or at least it was not for me. What I felt was a particular quiet that settles when a very long project reaches its correct conclusion. Not the conclusion a man hoped for at the beginning, but the one he built the right structures to absorb. That is a different kind of feeling. It is quieter. It lasts longer. That was May of 2023. Cobb Mechanical Solutions is still running. 87 people, steady payroll. I come in most mornings at 7:15, eat lunch at my desk more often than I should, leave around 4:30. My granddaughter Emma started 6th grade last September, which has nothing to do with this story and which I find remarkable every time I think about it. I replaced the oxygen sensor on a Saturday morning in late May. 38 minutes, a $31 sensor, and a socket set I have owned since 1987. The light went off. The truck runs clean. I kept the $14 shirt. I have worn it 4 times since the hearing. It is a good shirt, and it fits me correctly, and I have never needed a shirt to tell anyone anything about who I am, because I have a 29-year paper trail and 87 employed people that do that work more accurately than any piece of clothing I have ever owned. There's a thing my father told me in a machine shop when I was 19 years old, standing next to a press brake that had been running imprecisely for 3 days and that no one else had been able to correct. He stood next to me and watched me locate the tolerance error in the lower die, and he said, "The machine doesn't care if you believe in it. It runs or it doesn't." That's the whole conversation. He was talking about the press brake. He was also not talking about the press brake. I have carried that sentence through 48 years of building things, and I have found it to be accurate in every domain I have tested against, including the one I tested it against in courtroom 4 on a Tuesday morning in May, while a man in a better suit than mine explained to a judge what my shirt said about my worth. The machine runs. That is the whole conversation. That is the only conversation that has ever mattered. I almost felt sorry for Douglas Carraway. Almost. He prepared an excellent case against the man he had done his research on. That man, the one in the Walmart shirt with the Fidelity account and the resold Rockports, was completely real. He was also a partial picture, the part one chose to present. The rest of the picture had been filed with the Ohio Secretary of State and reviewed annually by a woman named Margaret Sloan, and it did not require my shirt to confirm it. A $14 shirt, a yellow legal pad with 2 columns, and a folder that Margaret had been updating for 11 years. As written, not a word changed. If you enjoyed this story, join our community by hitting that like button and subscribing for more real, raw, and family-centered stories. And as always, thank you for being a part of Dad's Raw Revenge. I will see you on the next one.